The Enron story you know is about hidden partnerships, cooked books, and a fraud nobody could have seen coming. The documents complicate every part of that. Enron disclosed that the partnerships existed. What it withheld was what they were. The accounting change began with a conditional no objection letter from SEC staff, and Kenneth Lay has no final criminal conviction because of a rule older than the crime. This is what the paper trail actually shows. Start with the most ordinary act in finance, reading the filings. By early 2001, short sellers had begun asking questions. One of them, Jim Chanos, had noticed the related party disclosures in Enron's own filings and pointed a fortune reporter named Bethany McLean toward them. She did the reporting and put the question in public. Her article ran on March 5, 2001. Enron was then the seventh largest company in America by revenue, trading at roughly 55 times trailing earnings. And by Fortune's count, 13 of the 18 analysts covering it rated the stock a buy. Its television campaign asked one word as a boast: why? McLean's piece did not allege fraud. It asked a smaller, more devastating question. Reading everything Enron publishes about itself, can anyone explain how this company makes money? Nobody could explain it. Not the credit analyst she quoted, and when she asked, Enron's own chief financial officer told Fortune, in print, "We don't want to tell anyone where we're making money." That sentence ran in a national magazine 9 months before the bankruptcy. Remember it. To understand what was in those filings, go back to a letter dated January 30, 1992. A Senate investigation later reconstructed the exchange. Enron had asked the SEC's accounting staff to accept a change for its gas trading unit, mark-to-market accounting. Under the traditional treatment, revenue from a long-term contract is recognized over the life of the contract, year by year, as the gas is delivered. Under the proposed method, Enron could record the present value of a contract's estimated future profit at signing and revalue it every quarter after that. Enron promised conditions. Its own request letter represented that valuations would rest on known spreads and balanced positions, and would not depend significantly on subjective judgment. On those terms, the chief accountant's office wrote back that it would not object starting in fiscal 1992. That is narrower than approval. It was a staff position for one unit on stated conditions. And then, 12 days after receiving that letter, Enron wrote back to say that on further review it would adopt the method a year earlier, from the start of 1991, a year the SEC had not accepted. The Senate report found no record that the agency ever responded. Enron simply went ahead. The method was not the fraud. Applied with honest inputs, accountants defended. The fraud came in the drift. Model-marked values on contracts with no market to check them, as Enron extended the method beyond the gas trading unit described in the exchange. It had already told the SEC it would apply the method to a year the staff letter had not accepted. Paper profits have a cost. Some of the deals behind them lost real money, and the losses had to go somewhere investors would not weigh them. Two structures matter here, and they are not the same thing. LJM was a pair of partnerships run by Enron's own chief financial officer, Andrew Fastow, standing on the other side of Enron's deals as a counterparty. The Raptors were hedge vehicles, created through transactions with LJM and capitalized largely with Enron-linked value. To let its CFO run partnerships trading against his own company, the board had to waive Enron's code of conduct, and the record shows it did. Anderson reviewed key transactions. Outside counsel worked on parts of the structure, but the record also shows the limits. Side agreements existed that, the SEC later alleged, were never disclosed even to Enron's auditor. The gatekeepers failed in different ways, and the record does not establish that each of them saw every material term. Here is the part the org chart cannot hide. The Powers Report describes what the Raptors actually did. A real hedge transfers risk to someone else. These, in the report's own words, functioned only as accounting hedges because Enron itself had supplied most of the capital the vehicles would use to pay Enron back. Strip away the structure and the picture is simple. Enron was insuring itself, largely with value it had supplied, and booking the insurance as protection. When Enron's stock fell, the investments and their protection fell together because both of them were Enron all along. Hold on to that test because it is not a period detail. Whenever protection is funded by the thing it protects, the insurance fails exactly when it is needed. That is structural, not historical. Hold the two halves of this fact side by side. Enron's filings disclosed that related party structures existed and that its own officer ran them. The footnote was public. What the filings withheld were the terms that gave those words meaning, the guarantees, the side agreements, the full extent of the officer's benefit. Disclosure in form, concealment in substance. That is why McLean's boring question was so dangerous, and why the company's answer, "We don't want to tell you," should have been the loudest alarm in the room. Inside the company, at least one reader had reached the same conclusion. On August 14, 2001, Chief Executive Jeffrey Skilling resigned after 6 months in the job. The next day, August 15th, an Enron vice president named Sharon Watkins sent Kenneth Lay a memo. Her words from the page: "I am incredibly nervous that we will implode in a wave of accounting scandals." Lay commissioned a review. It went to Vinson & Elkins, the same outside law firm that had worked on the structures in question, under a scope that did not include re-auditing the accounting. Read what that review actually said, because both halves matter. The firm recorded the problems: aggressive accounting, conflicts of interest, credit risk in the Raptors, and what it called a serious risk of adverse publicity and litigation. And then, within its scope, it concluded that the facts did not warrant a further widespread investigation. The warning was recorded. The investigation was bounded. 9 weeks later, the unraveling began. Then the paper caught up, and it took 47 days. October 16, 2001. Enron reports a third-quarter loss of roughly $600 million and separately discloses a reduction of about $1.2 billion in shareholder equity tied to the partnership structures. November 8th. The restatement. Enron refiles years of its own audited statements from 1997 through the first half of 2001, telling the market the numbers it had relied on should not be relied on anymore. December 2nd, 2001. Enron files for Chapter 11, at the time the largest bankruptcy in American history. Behind those filings were the people in Enron's retirement plan, their accounts heavy with company stock. In the middle of the collapse, a scheduled change of plan administrator temporarily froze participant investment changes. For 11 trading days, participants could not move their money. Across the wider lockdown period described in the Senate record, Enron stock fell from $15.40 to $9.98. The freeze applied to the retirement plan. Executives' personal holdings sat outside it, and executives had been selling for months. That mechanism has not aged. A retirement account concentrated in employer stock fails twice at once. The job and the savings go together. The prosecutions took years, and on the surface they delivered the ending the story demanded. Andrew Fastow, the chief financial officer who ran LJM, pleaded guilty in January 2004 and became the government's key cooperating witness. The executive who ran the partnerships and helped assemble the structures walked prosecutors through them, deal by deal. He received a 6-year sentence. On May 25, 2006, after a 4-month trial in Houston, a jury convicted both Jeffrey Skilling and Kenneth Lay. Skilling's sentence was later cut to 14 years under an agreement with the government, and he walked out of federal custody in February 2019. Lay faced the possibility of dying in prison. The story should end there. The paper trail does not. 6 weeks after the verdict, on July 5, 2006, before sentencing and before any appeal, Kenneth Lay died. Count what stood at that moment. The jury had found him guilty on 6 counts, and the judge, in a separate bench trial on bank charges, had found him guilty on 4 more. 10 guilty findings. On October 17, 2006, the court applied the abatement doctrine then controlling in the Fifth Circuit, vacated the convictions, and dismissed the indictment itself. Be precise about what that did and did not do. It did not find the evidence false. It did not erase the trial from history. It meant that a conviction that could never be tested on appeal would not stand as final. So, in law, Kenneth Lay died with no final criminal judgment against him. The same order denied Russell Butler's motion for restitution in the criminal case. Separate financial claims continued in civil proceedings. The Justice Department pursued a civil forfeiture action of approximately $13 million against property in Lay's estate, and the Labor Department obtained an allowed $12 million pension claim against the estate. The civil claims survived him. The criminal convictions did not. Arthur Andersen's reversal was different in kind. The firm had been convicted of witness tampering over the destruction of Enron documents. In May 2005, the Supreme Court threw that conviction out, unanimously, because the jury instructions had not required proof that anyone knew they were doing wrong. The court did not declare the firm innocent. By then, Andersen had already ceased operating as a major public company auditor. You could file all this under history, except for one detail. In July 2026, Bloomberg Tax reported that some large technology companies are financing AI data centers through entities whose debt is not consolidated on their balance sheets. The arrangements use a related legal structure Enron made notorious: the special purpose vehicle. Analyst Gil Luria drew the line that matters. Enron's crime was not having special purpose vehicles. Enron's crime was hiding what was inside them. And there the comparison must stop. Accounting rules have tightened since Enron. Today's structures carry more required disclosure, and nothing in that reporting establishes fraud or predicts a collapse. The useful question is the one this whole file teaches. Do the disclosures let you see who actually carries the risk? Form is public. Substance is the part you have to read for. The record proves something narrower and stranger than the story everyone tells. The structures were named in public filings while their material terms stayed hidden. SEC accounting staff did not object to something narrow. Enron extended it, and the agency did not monitor the conditions it had been given. And the reporting that opened the story began with an ordinary act, taking the public records seriously. My reading is not that the filings lied. It is that Enron used disclosure itself as the place to hide. The files are open. The question is where you think disclosure ended and concealment began. One question before you go. The abatement rule erased 10 guilty findings because Kenneth Lay died before his appeal. Put a 1 in the comments if you think that rule is fair, a 2 if you think it is a loophole, and the reason if you have one. I would like to see where people land. If you would rather read the filing than the folklore, subscribe. That is the whole channel.